now we get to the good stuff.
Now we're going to kind of move through this pretty quickly because we've said a lot of this.
What the notaries cannot do.
So again, can't keep your notary seals and journals in the workplace. Keep them within your control. Can't share a journal. Can't even allow anyone else to hold or handle their notary seals or journals. I mean, it sounds really, but just generally keep them to yourself, right? Because you don't want somebody saying that you let people handle it on a regular basis.
The reason is that this is a slippery slope. If you let somebody hold, touch, look at the journal, you allow a supervisor who isn't managing or supervising the notary program, but if you let somebody get their hands on this, that can become slippery slope to doing misdeeds with it. So go ahead.
I'm going to put a little plug in here too, that when you are performing notarizations, please use privacy guards. Okay? Identity theft is a serious topic. It's important to use privacy guards to keep that information private. One, your signers are going to appreciate the fact that if they kept the other people's information private from me, they're going to keep my information private from somebody else. Don't just hand over the journal, you know, when they sign so that they can see everything else that you've done. It's nobody else's business.
You know what she's talking about? Privacy guard are these different mechanisms that you can use to slide down the page of a journal so that the signer won't see anything above and won't...
Worst comes to worst, go out to Target and get those big old sticky notes. Seen these? Those big old things like that? They're like $3.47 for a pack of 40 feet. That's what we use. They're bright colors, they're really fun, but you just stick it on there. Done, can't see it. And then you can pick them up and move them around to make sure that you've covered everything you need to. Whatever it takes, just use something to guard the information that you use. I would just love that to just be part of that, okay? Can't notarize an employer or company document if any of the following is true. Now, conflicts of interest. Oh, God, this is another one. First and foremost, can't do it if the notary is named in the document, okay? If it says, Mary Smith will get this amount of money for doing this by when we sign this document, you can't be the notary and be Mary Smith. Doesn't work, right? The notary has drafted, prepared, or reviewed the document on path. You can't put a document together and go with this person and say, okay, this line means this means this, and this means that, now sign here and says that everything I just told you is true. You can't wear both hats. It's not a good idea.
This happens all the time.
There are some...
But it shouldn't.
There are sometimes it's a little different. Mortgage signers sometimes run into this issue, but they're not employer notaries, right? A little different.
Yeah. So we are talking about something that is a best practice. The one that bothers me the most that isn't relevant here, but to show you how bad it is lawyers, of course. Lawyers who have a notary commission all the time, they draft documents for their own clients. They then have the clients come in and the notaries notarize the client document that they themselves have prepared for their clients and for which they're charging them hundreds and sometimes thousands of dollars to have drafted or prepared those documents. What a conflict of interest that seems to be to Kelcia, to me, and to a lot of others, but the statutes don't prohibit it, and so lawyers do this all the time. Employees who are notaries should be bound by the same ethical practice. They should not be drafting, preparing, reviewing, consulting on documents, and then notarizing those same documents because they're not impartial at that point. If you've drafted the document and then you're going to notarize it, you're not impartial, it seems to us. So stay away from it, even though it's not prohibited by any statute. Don't do it just to keep yourself from the possibility that somebody's going to challenge one of those documents sometime.
And again, the notary has a direct financial interest. In other words, they put this document together. If they sign that, you will get some money whether or not it says that in there or not. That's the other conflict of interest, right? But now I get the point, well, if it's in the company's best interest to have something notarized, which it must be, otherwise why bother, right? And I'm an employee of the company. If the company benefits, then I benefit. Doesn't that make everything I do for my employer a conflict of interest? There luckily is one statute that seems to be for every state. I have not seen it in any territory that I have not missed it, where it says if you are a director, an employee, an officer of a company, you are still allowed to provide notarizations generally for that employer. That relieves that particular conflict of interest. We're talking about direct conflict of interest.
That wouldn't apply if the employee notary is getting a finder's fee, a procurement fee, a commission or something for that particular document, though. That's our point here. The difference is whether the employee might have a financial interest under some circumstances.
Can't refuse to process lawful requests for access to notary journal entries. Okay, I told you to keep that journal safe, but if your employer provides you with written request for certain journal entries, you must provide those journal entries to your employer. But they must ask for them in writing like anybody else would be required to in order to see journal entries. You must allow for that. Even if it's not for the employer, if it's somebody from the outside, if they give you a lawful request for a journal entry, you must comply to that. Whether or not your notary employer wants you to, you don't have a choice.
We should say that this, again, is one of those subjects, though, where state notary laws do not talk about accessing notary journals. Unfortunately, this is one of the things that is covered in the book's coverage of all those many topics where the statutes don't address when and how to do this. But it is the notary journal, since the notary is a public official, the journal is a public record of sorts, isn't it? It's the record of a public official. And public records are available through public records laws, and generally they are accessible, at least in limited circumstances, to members of the public. So you need to think about this, look into it, find something to read about the issues involved and how to go about doing accessing of journal entries, including, by the way, don't let me go too far here, but since if you get a request from somebody to get access to your journal, and then when you make a decision either to grant access or to deny it, what have you just done? You've engaged in an official act. So therefore, every time you get a request for access, whether you grant it or deny it, you've conducted an official act. You need to make a journal entry for that request for access. To say again, every time you get a request, regardless of how you handle it, you need to do another journal entry now for that request for access to your notary journal.
Even in cases where we're supervising, as I said, I do journal checks. We still send each notary, we're going to do a journal check, written request, and specifically these journal entries for this period of time. I have to do it. I send it to them in advance in writing before I can get it access.
Good for you.
Thank you.
I bet others may not be doing that.
I don't think they do,
yeah,
but they should, because it respects it. And then you can't charge notary clients more than the statutory maximum fees just because maybe your employer is taking a cut of that, which this gets very complicated. I am begging you, I don't know that we are going to have time to really dig into this in terms of who gets what fees and how much money, if there's going to be charges. And I find that a lot of times, especially if you're in a large company and you're a notary for a large company, you just don't bother to charge, which is your right, by the way. And that would be fine too. But this is a complicated series of things. If you have specific questions on this, let's talk about that afterwards. See Michael or I, read it in the book. This gets complicated, but it's not all that common. Once it's set out, once you've got it set out, then it, as long as it's right, you should be okay. So, I love the notaries that call me and say, oh, well, I keep a copy of everything I notarize. There goes my hair dye again. No, no, no. None of your business. Not okay. You've got your journal entry. That's all you need. You don't need to keep a copy of everything you do. Don't keep a copy of their ID either. Hair dye. Please, just journal it carefully and completely. That's all you need. Can't avoid personal, civil, and criminal liability and responsibility for wrongdoing just because your employer said to do it. Think of the notary in Wisconsin. Bankrupt. She's 59. Okay? You cannot avoid it just because your employer told you to do it. So even though it may be a difficult conversation to have, and I hope that it's not, and if your employer is really a mess, have them call me. I'll be happy to discuss it with them. Right? But please say no. In the politest, nicest, conciliatory way, beg them, but say, no, I really can't.
Well, and tell them why. The reason why is there's liability problem. This is no different from the law in other parts of the world of things, not just in the notary area, but it's not a defense. It's not a legal defense, in other words, for a notary to say, I'm not at fault because the employer told me to do it the wrong way. That won't work. It's the same thing if I hold a gun to her head and tell her to rob the bank, and she robs the bank because I'm threatening her, she's still going to be criminally liable for something there, me too, but she doesn't get to say, oh, he threatened me. It's not a defense.
All right. This is employers. All right, here you go.
Okay. There are a bunch of things that employers cannot do. They cannot request, instruct, or direct notaries to treat some notary clients differently or preferentially in the provision or charging for notarial services. We're talking about notaries here. If they've got a favorite client and they want to treat them special in other ways, that's up to them. But in regard to notary services and fees, can't do that.
It has to be one or the other, right?
Yep.
You have to have a set policy. This is the policy.
We already mentioned the second one. Employers cannot access notary journal entries for company transactions or other non-business notarizations without following the same procedure as required for anybody else. Again, we said up front today, if your state law says something different, obey your state law. California has a special law on this that may be different from this,
I'm
so
sure
don't
California
be confused.
has a law on every little thing.
Yeah. But other than California, I believe that this is correct everywhere else. And then the third one here, employers cannot obtain possession or ownership of notary seals or journals at the expiration of notary commissions when the employment terminates or at any other time. We've already been through that one, so I think we can move on. Next, employers cannot, unless a statute or regulation of the commissioning jurisdiction provides otherwise, here we go with fees, retain or share notary fees collected from notary clients. The lawyer in me wants to tell you why. If you don't want your employer taking some of the fees that you might collect at the workplace or sharing in fees, you could politely remind the employer that especially by taking the fees or sharing the fees for notarizations, they are almost certainly going to be liable if you make any mistakes. It is possible, depending on the circumstances, it is possible that the company will not have liability. We call it liability, vicarious liability in law. There is the possibility a company won't have liability for the errors and omissions of a company notary. Depends on the circumstances. But if the company is sharing in fees or taking the fees for a notary employee, you can bet 100% the company is going to have liability if the notary makes a mistake. So if the boss wants to take some of the fees, the boss is pretty well making a choice to at least have legal responsibility. Companies should be careful before they do this. The other reason for this rule, or best practice, I guess I should call it, is that the company isn't the notary. You're the notary. What entitles the company to be taking part of the fee for a public official who holds a commission and has full personal liability what entitles the employer to otherwise be taking or sharing in those fees. So this is a general rule, best practice, unless a statute, and again, California and a few other states have a statute that may allow the employee notary and the company to agree. They say agree when in fact we know what really happens. The boss says we're going to take the fee or we're going to share it. But if the employee and the employer agree, in some states this can be done.
But it's important to make sure that they tell you that in advance, that you guys, that there's a discussion ahead of time that if this is going to be our policy, then if a new person comes on board and they want to be a notary, that they tell them about it and for it ahead of time. And that it does in fact comply with the state statutes if there are any on this topic. And again, this is another situation where one size doesn't fit all. Certain companies don't care to charge fees because it's actually a service and they are fine with that and that works for them. But other companies, like you've seen them out there that provide notary services, places that you ship packages and things, and dry cleaners in the East Coast, which I've never quite got that connection, but they do, provide notary services. And that's part of their business service options that they provide, in which case they are charging a fee and they are keeping some of it. So that's a different situation. So again, you have to determine this, talk about this with your employer. If you're setting up a program, this is one of the things you're definitely going to have to talk about in advance, set up a policy about that is compliant with your state statutes if there are any, and best practices.
This last one I sort of alluded to earlier, but employers cannot avoid civil liability for notary wrongdoing in two situations. One is obvious. If the employer is the one who requested, instructed, or directed the notary employee to improperly perform a notarization. If the boss told you to do something wrong, you did it, the boss, you're going to have liability, but so is the employer. The other time that the employer is going to be liable is where employers have done nothing improper at all, haven't done a thing wrong, but where the notary employee nevertheless makes a negligent or an intentional error or omission while being in the scope of employment. This is called the common law doctrine of vicarious liability. I don't want to get deeply into this at all, except if you will, if you want to find out more, you can read about vicarious liability. But believe it or not, this is basically no-fault liability, isn't it? No-fault liability. If you're in the scope of your employment as a notary and you make a mistake, it happens occasionally, the company is still going to have liability in most states in the United States under the common law because in Old England they decided it's the right thing to do. It's the right thing to cause the party with the deeper pocket to pay for injuries caused by that employer with the deeper pockets, employees. It goes back to the 1700s. We adopted it in this country by our common law. We followed what Old England was doing, and so this is informational for the most part.
But this is what you'd use to go back to an employer and say why we need a notary program. Because whether or not you put together a notary program, if you have employee notaries, you are still going to be at risk. You will be at less risk if our notaries are trained and supervised and carefully, monitored. You are at less risk, but you are at risk regardless. So you might as well mitigate that risk as much as you can for both of our sakes, right? That's how you can get an employee. That's how you get the program. Yes, for notaries. Please get notary education. Get continuing notary education. If you go back to your offices and you have friends who are notaries in your coworkers who are notaries and they're like, oh, why would I bother with that? Please have one of these books and say, oh, I don't know, because this is what you don't know. Please, please be a part of that wolf pack, right? Help them understand that it matters, that what they're doing has consequences, and that they don't know what they don't know. And their state didn't tell them. Should keep copies of state or territorial notary statute and regulations. We keep them, we send them out to our employees regularly, and we ask them to keep them with their journal, right there. Know them, understand them, do the best you can. If you don't understand something in your statutes, call the NNA, call NLI, call somebody who's in an ethical representation and ask questions.
And the other thing is right here in the next phrase, or simply look up your state's handbook or guidebook that's online. These, many of these are very good. Many of these are saying the very same things that we've talked about that aren't in the statute, but the secretaries of state have figured out what are many of the best practices, and so some of this material is going to be in their handbooks and guidelines.
And you can just Google it. Google Montana state notary statutes. You will get several options. Easy to get your hands on. You should request employers to pay for notary liability insurance in appropriate levels of coverage. One size does not fit all. There are companies that provide very basic notarizations that their business insurance is going to cover, and the risk that their employee notaries are going to actually run into issues with, again, if they're only doing very basic state-requested things, if that's all they do, the risks are pretty low. So adding additional liability insurance is sometimes a thing that keeps employers from allowing a notary program. I would rather have an ounce of prevention than this liability insurance trying to get the notaries out of trouble once they're already in it. If I can keep them out of trouble in the first place, that's what I would prefer most, just for the stress, right?
But if the company and the notary are doing notarizations for customers, strangers, if they are taking on some
regularly
risk,
contentious documents, wills, states, power of attorneys, deeds, this is what you want to look at.
And you ought to suggest to the employer that they check their policy. A lot of them will say, oh, we're covered, we've got an umbrella policy. They think that umbrella is some magic term that means that everything on earth is covered, and it's not necessarily the case. Are any of you notaries at law firms? Any law firm notaries here? Okay. Some of those law firm malpractice policies don't cover notary misconduct, so they need to check. You need to make sure that the company and your employer needs to make sure that the company, if it has insurance, that it specifically covers notary malpractice.
So you should recognize that the higher the notary's position in the employment hierarchy and the more important the document or its underlying transaction, the more likely the notary should not notarize the document. This is one of those things where, again, I have to talk about in our most experience, which is advisor offices. We do not like advisors to be notaries, because advisors always want to do what's in the best interest of their client, where they want to make it easier for their client, right? Which may conflict sometimes with best practices. We would rather have it be somebody in the office, their office manager, their office employees, that hold the notarization and can do it for their clients. And a lot of times, we like to have 2 approved notaries in each office, because if you have multiple advisors, well then, the assistant to this advisor actually does that advisor's notarizations and the other way around. Again, we're trying to alleviate some of the possibility of conflicts of interest. Yeah. Okay?
And again, it's to protect against a possible challenge. It's better to be safe than sorry here in regard to impartiality.
Should work respectfully and professionally with employers if issues or conflicts arise, all right? It does not have to be contentious. You don't have to be in a full-on war with your boss. That's not what we're asking. Again, if you try and have this conversation ahead of time, keep it professional, talk about the importance of why it's important for your employers as well as your notaries to have a program and a supervisor of that program that creates this buffer. It alleviates a lot of these things. But try and do it ahead of time and agreeable. Most of the time, that will help mitigate most of the serious issues.
I just recently finished with a case I was involved in where And a notary did a lot of notarizations for the boss. And the notary was afraid of the boss. And the notary did a notarization for the boss that was a verification on oath or affirmation. The notary did not do the oath because the notary was afraid, since the boss always just left the documents on the notary's desk and wanted the notary to sign and notarize and not be bothered. So the notary didn't swear the boss in. Turned out the boss had lied in the document, and the lie was discovered, and the boss was charged with perjury, a felony. Turns out the boss said, hey, I didn't take an oath, and the notary admitted she hadn't administered an oath to the boss, so it turned out that the notary had then committed a crime. You know, we haven't mentioned this today, but in most states, in almost all the states of this country, if a notary fails to perform a required act, such as administering an oath for a jurat, that is called official misconduct, is the crime. Almost every state has an official misconduct law or something.
Listen to that word. It's a crime.
Yes, crime. So it turned out the notary in this case was facing a possible criminal charge as well, but the state granted immunity to the notary so that the notary would testify against the boss. They wanted the notary to roll over on the boss.
But you better not count on that.
Yeah, well,
right?
It may
Let's
or may
not count on that.
No,
so the point is, again, withholding that thing. The whole point of an oath, right, is to nail, they want to be able to say, if it isn't right, that they can go after somebody for perjury, really, right? If you say something is true and it's not, and you swear it, then you've perjured yourself. If they can't go after that person for perjury because you didn't put them under oath, they're going to go after somebody, and guess who it's going to be?
So the point of the example is there is a true risk if you let the boss control your performance as a notary. Turned out in that case, since the boss hadn't taken an oath, he couldn't be prosecuted for perjury. He was charged with something else. But it was a real bad situation, right? That would not be a pleasant workplace after this was all found out. So avoid that.
So let me ask you a question. How many of you were notaries before you ever took any notary training? All right. Did you ever perform something that after you took notary training you went, oh dear? Yeah? Can you see how that happens? Right? State didn't tell me. State didn't explain the point, the difference between acknowledgments and jurats. It's not in statutes, right? Only notary training can truly help you understand how to do this properly. Just getting a copy of the statutes isn't enough, and that's what you have to help your employers understand, that training is the thing that matters. And the states don't provide it. Why not? If you're going to commission somebody to do something, why aren't you telling him what to do? Ah! Okay, this is another one of those where he and I disagree necessarily. He says keep one at home and then have one at work, okay? I like one journal. I like one pattern of behavior for everything I do. But if you're going to be traipsing it back and forth, then I would rather that you have it there. But a lot of employer notaries that I know, they only do it at work. I'm not doing it for my neighbors necessarily. I don't necessarily broadcast that out. And so generally I keep my stuff at work locked up, okay? And I would rather you did that, one or the other, right? If you're going to go back and forth, then have two. But if you're going to just do it in one place, don't traipse it back and forth with you because you will lose it. I will have lost at least six journals now, I've been told, have been lost in their car. They must have very big cars.
And again, one or two states in the country don't allow this. They permit only one present active journal at a time. But if the state law doesn't prohibit this, it's up to you to decide how you want to handle it.
I'm just telling you, people lose amazing stuff, and they will lose it. They lost it in a move.
I'd be willing to take some questions for
ready,
a few
so
minutes.
I think we'll just talk this.
The question is, if you're notarizing for somebody more often than one time, do you need to do identification all the time?
No, because if you have a solid understanding, you can use personal knowledge. in most states. Is there any state that doesn't? California. Yeah, some states don't allow that, but yes, in that instance, you're going to have to provide that. Yes, it's a pain.
Here's one where we disagree. I would ask for identification every single time. Why? Not because I don't know who I'm dealing with at that point, because I want to be able to write it in my journal that I saw ID and I want to put the issuance or expiration date or so on, because it's one thing for me to say, oh yes, I knew from personal knowledge this person and so on. But if I have it in writing, you know, if I say I know somebody personally, that's ambiguous about how long do you have to know, under what some circumstances do you have to know somebody. But to me, it's a lot safer for me as a notary to get ID every time, record it in my journal, so that if there's a challenge, I can say, look, I've been using personal...
Right, but you're a lawyer and I'm an admin, let's say, and I'm doing notarizations for my boss 55 times, and my state does not require me to do an ID every single time. Now, your boss, how long have they been your boss? Here's my test. You're on vacation in Fiji. You're walking down the beach in Fiji on vacation, and your boss walks down the beach, and you're going to go, Joe, what are you doing here, man? I thought you were supposed to be over here. You know him by sight. You know his name of his kids. You know who he's in. I know the admins, right? Every single time? Probably not. That's where personal knowledge can come in. You are going to get further, because if you ID somebody without needing to, your state doesn't require that, and you want to pull out this ID every time, that's when you're going to have these issues where employers don't want to do this, right? So but you have to make sure that it's clear. Personal knowledge cannot mean, I had a lady, we have a corporate office in Minneapolis. There's 8,357 people in that office, literally. That's our office. She said, well, if they work in this building, I say personal knowledge. Hair dye! You cannot justify that you personally know every 8,000 people. Are you nuts? So, pay attention. Think this through, okay? So tell him, the state statute says I'm supposed to look at your ID every time. Just every time you come, have it with you. Do you have your ID with you? Yes. Show it, wave it at me. Okay. Is it changed in any way since the last time we did a notarization? Have you renewed it? Has it got a different number? Did you move? As long as it hasn't changed.
Yeah.
Yes.
But he doesn't want me to charge them.
Okay, well, you get to choose what you are willing to notarize and not notarize. And if he's not going to have you let you charge for it, say that I'm not really going to be able to process these documents. I'm sorry, that's not a reasonable request.
The question is, if you're going to be a notary, should you have a company like an LLC? Of course, that's going to depend on if you're just doing occasional notarizations for a few dollars. I don't think that I'd bother. Having an LLC is not going to, by the way, I see what you're concerned about. You're concerned about liability.
Liability.
And a public official can't be an LLC. So you're not going to be able to do an LLC as an individual for your individual notarization of documents. Now, if you wanted to have a notarization company...
You'd be better off getting personal liability insurance in that situation.
If you wanted to have a company, a mobile notary company, or a company, the company can have an LLC, and you can purchase insurance that way, but you're not going to avoid liability as a notary under the LLC laws because you're a public official.
Resources you have. Don't feel like you have to do this on your own.
Right. NNA has a hotline. The American Society of Notaries has a toll-free number.
So if you
Richard's
don't have
company.
a program, there's your buffer. Remember I told you?
Yeah.
Somebody
Get
between
help.
them. So you could
Get
say
help.
to your boss, oh, no, I totally would do this, but I just called the NLI and they say we can't do that. We'll be in trouble. Oh, okay, as long as they say it, now it's okay. And it removes that.
Our last comment, question, or?
Yes. Remember journaling, right? It asks you what you charged. If you don't charge anything, write 0.
Yeah, right.
If you get audited by the IRS, If you didn't put anything, they can assume that you charged up to the statute of limitation, what you were allowed to by your state statutes, and if you didn't claim that as income on your taxes, you can be in trouble. So just write 0 if you didn't charge.
We appreciate
Thank
you
you,
came.
guys.
Hopefully this was helpful.
Thank you very much.
Thank you.
Go be part of the wolf pack.